Learned Senior Advocate Jorge Namka sir to kindly present the traditional Sikkimese Khada to the distinguished panel comprising of Honorable Mr. Justice Atul Sreedharan, Judge, High Court of Judicature at Allahabad. Honorable Mr. Justice Ravindra Maithani, Judge, Uttarakhand High Court. Honorable Mr. Justice and Sanjeev S. Kalgaonkar, Judge, High Court of Madhya Pradesh. I now request the learned senior advocate Tashir Abdin Barfungpa sir to kindly present the traditional khada to the moderator, Honorable Mr. Justice Anjani Mishra, former judge and vice chairman, E Committee, Supreme Court of India, to open. I kindly request the distinguished moderator for this session, Honorable Mr. Justice Anjani Mishra, former judge and vice chairman, E Committee, Supreme Court of India, to kindly open this session.
Good afternoon, everyone. I hope I'm audible. Uh, we'll begin by the opening remarks by the chair, Justice Bishnoi.
A very good afternoon to all. Brother Justice Arun Bhansali, Brother Justice Atul Sreedharan, Brother Justice Maithani, Brother Justice Sanjeev, Brother Justice Anjani sir. Today we are here to attend this 2 days conference on technology and judicial education. The theme of this session, rule process alignment and re-engineering, captures the most critical challenge we face in our leap towards the digital judiciary. We often talk about technology, the apps, the portals, the AI, but I would want to point out before that technology is merely a tool. The real reform, as the session rightly indicates, lies in re-engineering the foundational processes of the existing judicial system, aligning them with the rule of law and establishing an institutional vision. It is to be borne in mind that digitalization is not the mere replication of an offline process on a screen. In its true sense, digitalization ought to and should mean true re-engineering. That is to say, doing away with the outdated rules and the practices. Re-engineering the process means to enhance the judicial productivity, both qualitatively and quantitatively, to make the justice delivery system affordable, accessible, cost-effective, transparent, and accountable. This is the mission, and at heart of this re-engineering lies the e-filing. Now, the stepping stone towards the process alignment and re-engineering are the mandatory electronic filing, e-filing. And it is not merely about scanning paper documents and uploading them. It is about re-engineering and fundamental processes of the court administration. The core reform lies in linking e-filing to the back-end automation. All statutory judicial registers, daily cause lists, filing registers, motion lists, final order, judgment register should be automatically generated from the structured metadata captured at the time of filing. In other words, when a party files a petition, the system extracts data fields, the party names, case type, relief sought, lawyer details, etc., and immediately populates the register. This eliminates manual register writing, reduce human error and duplication, and prevent inconsistent cause title indexing. By removing these manual steps, the registry can shift from being a data entry center to a quality control and case management hub. This is process re-engineering in action. We see the principle being vigorously applied across the country. For example, the Rajasthan High Court, on the instructions of the Supreme Court, has made e-filing of all division benches cases mandatory, with civil cases following suit, pushing for a compulsory paperless High Court. The Bombay High Court has mandated e-filing for a host of matters: commercial division, direct and indirect cases, and non-commercial arbitration cases, even introducing an online Google form for urgent listing to reduce paper inflow. The Delhi High Court has given a slew of directions to strengthen the e-filing across the district courts, including mandating it all for all civil jurisdiction and criminal complaint cases, which is very essence of aligning rules with the digital process. Even the Punjab and Haryana High Court now mandates e-filing for specific cases categories like civil writ petitions. This is not a scattered effort. It is a national re-engineering movement. Now we come to the court management and case management from the registry to the bench. We have to understand that e-filing is not the end, it is the base camp. The track to the summit is a paperless judiciary. After implementation comes next the great challenge, which is case management. If our processes are truly aligned, e-filing should not just change how we file, but how we manage. Once data is uploaded, automation technologies and AI can be deployed to process matter. We are already seeing this in Supreme Court, as the Supreme Court, in collaboration with the IIT, has developed and deployed AI and machine learning tools integrated with the electronic filing software and identification of procedural defects in petitions. These tools are enable metadata extraction, party names, case category, relief, and can also be integrated with the integrated case management and information system. Once integrated, we could create a system which would reform the entire system and registry level duplication, and registry level duplication can be avoided. This system would work as follows. Once a defect is identified, the system notifies the filer with a time window to cure it, exactly the registry level duplication that the core reform seeks to avoid. Furthermore, this technology can help in intelligent listing. E-Code Phase 3, 2023 onwards, puts in place intelligent smart system enabling database decision making for the judges and registries with the scheduling on prioritizing cases. A specific goal is automating the registry role in listing of cases to bring transparency and reduce manual intervention. Some of the examples of our High Court: a pan-India re-engineering. This re-engineering is not a distinct dream, it is present reality, albeit the teething issues. The Sikkim High Court is on the course of become a fully digitalized and paperless High Court, a beacon for others. The Madras High Court has mandated strict adherence to e-filing for criminal cases, and while it had to put a district court mandate on hold due to some teething problems, but I think so now it has been informed that they are going to implement it soon. It showed a commitment to streamlining the process through the coordinated efforts with the police and judicial staff to rectify lapses. This highlights a critical aspect. Process re-engineering must go hand in hand with the addressing stakeholder concern. To conclude, the use of ICT system is not just about efficiency, it is about reinforcing the rule of law. Every file uploaded on an electronic system captures its metadata, timestamp, user detail, edits made, creating a transparent and tamper-proof record. The e-service summons is a game changer. The e-committee has launched NSTEP, a centralized process service tracking apps enabling bailiffs to serve notices electronically, track their GPS location, and capture proof in real time, drastically reducing delays. As we move forward, complete paperless system, we are duty bound to ensure this re-engineering is inclusive. Our vision must be to ensure just for all, beyond all physical boundaries and disabilities. We must equip our legal services authorities with the necessary manpower and resources. The establishment of e-filing help desk counters in court complexes and the Nyay Kaushal e-resources center are steps in the right direction. Technology, after all, is a means to higher goal. Our re-engineering process must be guided by the core values of access and inclusion, ensuring that the benefit of a transparent, efficient, and speedy justice system reach the last person in the queue. Now, what we are discussing about the challenges, but these challenges will come once the e-filing is made compulsory in all the courts. We hope that soon it may be the dream come true. And I've been, when I was discussing with brother Arun Bhansali, then he was telling me that Supreme Court is also thinking on this line, and they asked from some officers about to prepare this type of system, that how to minimize this paper in the this registers, and how to do all this paperless. And I think so. Brother Anjani ji will throw light on that. This now, this is what we are. We could face these challenges. When the paperless paperless court and this will come to the ground. Now I'll request Brother Bhansali to throw light on it. Some.
Honorable Justice Bishnoi, Brother Justice Atul Sreedharan, Justice Ravindra Maithani, Justice Kalgaonkar, Brother Justice Anjani Mishra, Chief Justices, Computer Committee Chairpersons, and distinguished experts and fellow participants. It is indeed a privilege to be a part of this landmark national conclave on technology conference. A conclave of this nature for reviewing the past, re-engineering the present, and redefining the future could not be more timely. As we gather here today, we stand at a pivotal moment in the journey of India's justice delivery system. Over the last 2 decades, the Indian judiciary has made remarkable strides through the e-court project. We have introduced e-filing, virtual hearings, digitized records, and online case portals. Millions of citizens can now track their cases from anywhere. These were necessary and important first steps, the phase of digitalization. But digitalization alone is not enough. Simply scanning papers or replicating manual processes on a computer often replicates old inefficiencies at digital speed. True transformation demands something deeper: process re-engineering. Process re-engineering means fundamentally rethinking and redesigning our workflows. not just automating what exists, but questioning why it exists and how it can be made radically better. It requires rule alignment, ensuring that our procedural rules, statutes, and institutional practices are fully synchronized with the capabilities of modern technology. As was question was put by Brother Suraj Govindraj, that when the e-filing is made, then objections are raised by the office that it is not provided in the rules. So the rule alignment is that you have to make rules which are friendly with the e-filing. This is a shift we must make from digitalizing the registry to re-engineering the registry itself. At the heart of this re-engineering lies one of the most impactful reforms, mandatory e-filing designed to replace physical institution registers. Imagine a room filled from floor to ceiling with dusty leather-bound registers. That was the physical memory of our institutions for centuries. I'm reminded of a personal incident way back in one of the matters where there was a overwriting in the physical file regarding the date of institution. So my senior told me that go to the record room and find out from the register as to when this matter was actually filed. So I went there. The officer who is posted there is normally on a punishment posting. So he told me that those registers are lying somewhere. You go and search and find out. So it took me 1.5 hours. And when I came out of the record room, I was filled with dust and DDT powder, because DDT powder is kept in the record rooms for ensuring that there are no insects there. So that was the position. At that point of time, it continues to be so, because yes, it continues to be so, but just to replace it from something better, or rather by a click of a button sitting in the office itself, we would know that when the matter was filed. Today, when a case is filed, the registry still manually creates and maintains multiple physical registers. Lawyers or litigants submit documents, registry staff scrutinizes them, and enter data and again. Index causes titles and update various statutory registers. This multi-layered manual process is time consuming, error prone, and resource incentive. The new vision is clear and powerful. When a litigant or advocate files a case through the e-filing portal, structured metadata captured at the very moment of filing should automatically generate all statutory registers. No separate manual entry, no duplication. The system itself becomes the single source of truth. This reform is not merely technological, it is profoundly institutional. It requires us to align our rules of practice, civil and criminal procedure rules, and the High Court registry's guidelines with digital realities. We must amend or issue new rules that recognize electronically generated registers at the primary and authoritative records. By capturing structured, standardized metadata at the point of e-filing, party details, nature of case, statutes invoked, relief sought, annexures, and more, we can auto-populate everything downstream: registration, scrutiny reports, defect memos, cost lists, and statistical reports. This single change helps us eliminate five major demons of the current system. First, manual register writing. Hours spent by registry staff filling bulky registers can be completely eliminated, freeing human capital for higher value work and ensuring 100% accuracy. Two, registry level duplication. The same information will no longer be entered multiple times across different systems. Enter once, use everywhere. Third, post scrutiny data entry. No more re entering data after defects are cured. Scrutiny results will be tagged directly to the metadata. Fourth, inconsistent cost title indexing. Variations like AB and company versus state. Now you will find that somebody will say AB and company CO dot. Somebody will say COMPANY. versus the state, somebody will write a state, somebody will write state of UP, somebody will write state of Uttar Pradesh. So they will be all different. Being indexed in 5 different ways will end. Structured metadata will ensure a single searchable standard. Fifth, inefficient and unintelligent listing. The advantage of this reform is intelligent, automated, causeless generation based on real-time metadata, case type, urgency, parties, etc., free from human bias and delay. Rule alignment and process reengineering must be guided by a bold institutional vision, user-centric design, processes built around the need of litigants, advocates, judges, and registry staff, data as an asset, accurate real-time metadata, turning our systems into powerful tools for analytics, dependency reduction, and policy making. Standardization with flexibility, uniform national standards for metadata while allowing high courts reasonable accommodation for local needs. Integration and interoperability, seamless connection between e-filing, case management, payment gateways, and future AI tools. Capacity building, continuous training so technology becomes an enabler, not a barrier. This transformation will not be without challenges, resistance to change, data security, and privacy concerns, bridging the digital divide and ensuring robust infrastructure for disaster recovery. These are soluble if we approach them with collaboration, institutional will, and continuous stakeholder consultation. When we succeed, we will achieve faster case registration and listing, reduce pendency through elimination of avoidable procedural delays, greater transparency and tamper-proof records, lower costs for litigants and the system, better utilization of judicial time, enhanced public trust in the justice delivery system. Several high courts have already taken pioneering steps. We must now scale these successfully nationally through aligned rules and re-engineering processes. As Justice Bishnoi just said, we were discussing, and I have information that e-committee at the national level is now getting into this re-engineering and rule alignment thing. So let us hope that we get a something which can be implemented across the nation. In conclusion, moving from mere digitalization to genuine process engineering through rule alignment is the next frontier in transforming the Indian judiciary. Let this conclave not just be a platform for discussion, but a catalyst for decisive action. Let us commit today to reviewing and amending procedural rules that hinder digital efficiency, prioritizing the capture of structured metadata in e-filing systems, making auto-generated statutory registers the new normal, building an institutional vision that places technology at the service of justice. As we re-engineer our processes, we are not just modernizing a system, we are reaffirming our commitment to the constitutional promise of justice, social, economic, and political for every citizen. The future of Indian judiciary is digital, efficient, transparent, and public-centric. Together, through thoughtful rule alignment and courageous process re-engineering, we can build the future. We have a very enlightened panel. We look forward to your valuable insights and deliberations in this session. Thank you.
Thank you, Justice Bishnoi and Justice Bhansali. Basically, what emerges is that the discussion needs to focus on what areas require process re-engineering. And especially when we talk of process re-engineering, to my mind, there are two aspects to be considered. One, for making the process user-friendly, and secondly, to ensure that it is aligned with the legal requirements. Now, I'll give you an example. Under the CPC, when the suit is filed, there are certain provisions which provide that certain documents which are the basis of the claim must necessarily be filed along with the plaintiff. Now, how do we deal with this when we are moving towards mandatory e-filing? This is one aspect which requires consideration and discussion. The other thing, of course, is of manual registers being maintained. That should not be a difficult process, but I would like to have the views of the panelists as to what their high courts have done in this regard. Justice Sreedharan.
So thank you very much, Justice Mishra. And Justice Bishnoi started off and gave a very large and a great overview as far as the subject is concerned. And he also mentioned how this technology is to be used as a tool and it's not an end to itself. And that the digitalization is meant to, as a means to re-engineering judicial productivity. And then he also mentioned about mandatory e-filing, which was already considered and discussed in great detail in session one. And then linking of back-end automation to the to be generated automatically. As far as this is concerned, sir, you had also mentioned about a pan-India re-engineering of the filing process itself and the pitfalls that can come in the way. In fact, just coincidentally, I was discussing with brother Sanjeev Shukla during over a cup of coffee. He had mentioned that why do we have so many different nomenclatures? Where different courts have different nomenclatures for their cases. And in fact, even one high court which may have a particular nomenclature that is sought to be changed when the chief justice changes. They want, he feels it should be a slightly more easier one. So, Justice Mishra, with your permission, can I just bring in Justice Shukla over onto this about the conversation that we had?
Yes.
What was your views on having that common nomenclature, sir, if you could just mention it?
Just to fill you up, this exercise has already been undertaken by the committee once in 2017, and probably it was shelved. What they did was that different nomenclatures were mapped to one another in the software, but the nomenclatures of the various high courts were allowed to exist as they were.
Anyway, we were discussing on this issue, saying that whenever the chief justice changes, if he comes from south, he brings the nomenclature from south. If he comes from north east, he comes with that nomenclature. So each time we have to go for new nomenclature. Why can't we have pan India same nomenclature? If say latest patent appeal or intra court appeal, it should be intra court appeal everywhere. Uh, but that would make it further easier uh, for detecting the data on a national grid also. That how many LPAs across India are pending. But if there are different nomenclatures for different high courts, then it's very difficult to discern that intra-court appeals, how many intra-court appeals are pending, pan-India, how many criminal appeals are pending.
So
Some
that's
are
a practical difficulty, what you're saying in a pan-India re-engineering,
that,
if it's
that's right.
if it doesn't have a common nomenclature.
And second suggestion was that, like we are discussing here, that we have to realign the rules with the changing technology. Why can't we have a model rules prepared by E committee of the Supreme Court and replicated by all of us with some small modifications, if at all required at the regional level? But we have all the high courts have different rules. We could understand the high court rules may be different, but so far as this E regime is concerned, we can have a one set of rules which is uniformly applicable and is replicated everywhere, and model rules can be prepared by the E committee of the Supreme Court.
Precisely for this purpose, we are in the process of setting up an office consisting of 5 judicial officers to look into these aspects and to frame model rules. So
Right.
that process is underway.
Right.
And Justice Bhansali Saab, you said that one of the main aspects that you pointed out was no separate manual registers to be maintained. Now, that would be the crux of process reengineering. The very purpose of that would be to reduce the duplication of data. And if we can, I was just thinking whether it does exist or not, whether you can have a system where even if a physical copy is presented in the registry, from the point of scanning onwards, creating the index, marking the page numbers, and right down to the storing of the data in the servers to be utilized by the judges, the lawyers who are all linked to the same system, sir. And but there comes in the problem because as far as data integrity is concerned, once the data has gone into the servers, how do you ensure that the data integrity is maintained? So as far as my technical knowledge, sir, is limited. So, sir, with your permission, can I just get it, Justice Suraj Govindraj, on this on blockchain? On blockchain, we how see once the data is scanned and it goes into the servers, how do you continue to ensure that the data integrity is preserved and that there is no subsequent change to what has been scanned?
So there's a popular misconception that blockchain cannot be hacked. It is not that a blockchain cannot be hacked, even a blockchain can be hacked. The blockchain works on a multi-ledger platform where the same data is stored in different places, and the uh, presumption or the assumption is that even if a person were to hack one place, he will not be able to hack all places simultaneously. So if the data is in 10 places, even if by some quirk of fate and by some providence, if somebody were to hack into three places the data will change, but seven places the data will not change. And there being a date and timestamp, those seven places where the data is not changed is taken as to be the valid and verified data.
And it will also, but the advantage is that the blockchain would at least identify that the document has been tampered with.
Exactly. Now,
That much it will
once
give.
it is hacked into these one, two, three places, there'll always be there's a hash value comparison which keeps on happening between all 10. And when the hash value comparison happens, it shows throws up a trigger. It shows up a throws up a warning saying that there is somebody who has tried to hack it, and this particular data has changed. So that is known to all the 10 places. And that time, these three can be put back to the other seven original, so you'll always continue to be having the original, the proper one, verified data.
So, and Mishra Saab, what you had picked up was especially in suits when they are filed in the trial courts, that's a major problem because the original document has to be filed along with it. Only that can be exhibited. But at the stage of the High Court with regard to writs, I mean, the original documents are not required, the photocopies are sufficient enough. So, wouldn't that at least be workable in the High Courts?
It could be. That is how these rules, e-filing rules, have been structured in the Allahabad High Court and the various high courts. But just a thought, especially in testamentary jurisdiction, the will is always required to be filed. Once probated, it is kept in the registry. So probably we can have some sort of a registry where these documents, which are mandatorily required to be filed, are kept, so that the courts can at least take a look at the original and not rely mainly or exclusively upon photocopies.
So, sir, I give it back to you, sir. You can. Next question.
Another this about the maintaining registers and all. This is also part of the rules that
Yes, yes,
the
it is.
courts has to maintain so and so register. Then we have to mandatorily amend those rules also for that purpose.
Yes, rules have to be amended. That's why I said that process re-engineering also necessarily entails relevant modifications, amendments in the rules and the law.
Then you have to when you are thinking over it. So what's the idea about it that you will provide rules, universal rules for all the courts in India, or
That
what?
is the idea at the moment.
At the moment? Yes.
But again, the problem is that we we can only suggest. As the e-committee, we don't have any uh,
That power to
power to
or to
direct any high court.
that is
Ultimately, it is the high court which has to.
so once
Yes.
once we are thinking of it,
Yes.
then certainly all the courts or all the high courts will follow it. What's the problem in
No,
that?
no, that is not a problem. But that is just one issue. Sometimes the high court feels that something is being pushed onto them unnecessarily. That is also
That we can take care of that.
Justice Maithani, would you have to add something?
Uh, Honorable judges, on and off dais, thank you, Sikkim High Court, for being paperless, showing the path, and making all of us feel proud that we are part of a system due to amalgamate with the National E-Governance Plan now. Before I come to this process re-engineering, I would like quickly go in the past. Before this CIS or E-Court we started, earlier also attempts were made to computerize. So the word that time used was computerize the courts. In UP, that was District Court Information System, which was initially phased out. It did not work. as Justice Mishra has rightly said, that E-committee is not creation of any statue. It's administrative orders. Just the then Chief Justice Lahoti just wanted that to assist me, there should be a committee. That is how it come into existence. We must not forget that process re-engineering has to be done. We cannot afford not to do it. Just a few days back, when I got information for this conference, I was in a court. I asked that why you are not giving slips for any document that is filed in the court and registered in the CIS. They said the rules have not been changed. We don't have that rules. The provision is in CIS, but the clerk is not giving it because rules doesn't permit it. Here is process re-engineering. And as an e-courts, let us think of it. As an e-court, we have not innovated something as a judiciary on our own. It's a national e-governance plans component is this, which was launched in the year 2006. And e-court is one of it. Today we know that if we need to get our passport, it's a paperless. ITR, paperless. Banking, paperless, most of it. And multiple departments, pension, land records, paperless. We are not pioneering it. We have to integrate with it. Otherwise, we would be lacking behind. And 2007, when first action plan was launched, I wish we would have read, if not heard, read the speech given by the then President of India, Mr. Kalam. He envisages what we are envisaging today. A total paperless scenario. He would talk of a national ID and going to the portal, looking for the lawyers, making pleadings, information to the opponents, and all those documents. If it is a land document, from land record grids, verification. If it is a bank records, bank grids, confirmation. And similarly, when the defendants puts the cases, then hear virtually and decide the cases. That speech is basically that's something to be read. Now, what will happen of the registers? Entry once made in the grid anywhere in the Indian judiciary, that should not be re-entered. We should be able to capture it, navigate it. We should have horizontal and vertical integration. I had a lot of privilege to be associated with these projects. I know this Madhya Pradesh High Court, they had integrated the courts in vertically also. I did not define it in a greater detail. But when we talk of right now, the topic is rule alignment. Rule is for what? To my understanding, we need to first visualize what we want to go, what we want to do, how our system should work. And this is integral part with the ITting and the judicial setup. For my high court, if I want to go for e-filing, somebody files a petition and not in a PDF form or scanning, no. Some forms which are in many forms, just filled, data capture, scrutiny, notification to the adverse side. In the meanwhile, since even today in the criminal courts, we get some data from CCTL. We get some data from e-prison, e-forensic, that's available, interoperable judicial system, at least in Uttarakhand, it's operational now. And a step we have changed our rules. E-summons, we have changed our rules. Our summons police officers is not giving that for the report now. It's vertically on the GPS based. So once we have a plan to do it, we may do those things in pieces, but our rules should be made once we reach that place. These are the rules now. So that should be the process. As far as the registers are concerned, in UP and Uttarakhand, I have seen perhaps this general rules service, there are hundreds of registers and 80% of them are obsolete. Why do we need those hundreds and thousands of entry? Today, with a click of mouse with many combinations, we could get the data. What data we need? Even if from NJDG, we could get those data from each court. So registers may be done away, but yes, who will do it? That's very important. And time has come for all of us, personally, I feel, that sit down and work on it. What should be the rule alignment? How the system should work? And it's not doable. It has been done here where we are sitting today. So anyone can do it. So how we want our code to work, and then all those rules definitely would be obsolete For example, in Uttarakhand, we wanted to have e-true copy rules. So when we were discussing, they said, who will pay the paisa court fee? I said, do away with the fees. Give it free of copy. All right, it's a rule. We have created 2 ANA per page earlier. 2 ANA. So no paisa. We are not taking any paisa. We have e-court rules, and within 30 seconds, one could get a e-true copy. Anyone can get it. And believe me, lawyers have given representation now that the copy should be given to lawyers only. And it was full court agenda.
Yes.
What should be done? We rejected. We have gone far ahead. Why should come back? So my take is that rule engineering, this we have multiple questions. For example, then we have to validate. For example, service sufficiency of service. If the services has somebody has on the structured form filled a writ petition, say, and notice goes through mail or whatever mode he has in WhatsApp number, everything. We know that we get the receipt through mail also, e-post or whatever that. So that should be given validation. Multiple verification, maybe in the Bharatiya Saksha Adhiniyam now and Bharatiya Nagrik Sanghita. What is that? So we in very tough to remember the word. So we need amendments and authorization and certification at that level also. Means the chain should be at that level also. Once we go 100% that ecosystem. So that's my take, and registrars may, and yes, we cannot afford to say no. Rules are to be aligned. We have to work it, whatever manner we do it. Otherwise, we will be. We take pride that in COVID period we have done tremendous task. We have done it. Of course, we have done through VC video conferencing. It was an ad hoc kind of things. But when we talk of paperless an ecosystem, with the now we should have the rules. How to push the information? How much access should be given to other cases? Support land record, they want from us. So these and many such things may be perhaps require deliberation. Thank you very much. Thank you, Chief Justice Mustafa, for giving this opportunity. Thank you so much.
Thank you, Justice Maithani. I'm told that Madhya Pradesh High Court has done very good integration right to the grassroots level. So therefore, probably Justice Sanjeev Gaonkar may enlighten us on that.
Honorable Chair, Honorable Justice Vijay Bishnoi, Honorable Chief Justice Arun Bhansali, Honorable Vice Chairman of the committee, my senior, my guides, Justice Sreedharan, Justice Maithani, and Mr. J. Honorable judges here. I'll start with a statutory warning, sir. I have worked for 20 years in the ground level, for 7 years at the higher level, and for 5 years at the highest level. So I have bag full of experience and 3 bag full of advices. So please restrain me if I go tangent or cross my limits. I'll start with the rule. Why rules are required? So now Bharatiya Nagrik Suraksha Sanhita and Bharatiya Saksha Adhiniyam 2023, they came into force. Section 54, 94, 105, 180, 185, 202, 209, 230, 231, 251, 245, 262, 265, 266, 308, 310, 316, 335, 356, 392, and the last provision, but very important provision, 530, recognizes electronic evidence. Then Bharatiya Saksha Adhiniyam, section 57, 61, 62, 63. And certain electronic processes are made mandatory. It would be mandatory to record the search and seizures. It would be mandatory to record the video of crime scene. It would be mandatory to record the statement of vulnerable witnesses. Rules are there. Provisions are there, but rules are not there to recognize this. Where to keep this electronic evidence? Where to keep? On pen drive? On DVD? In 2016-15, we made the rules recognizing the use of DVDs. Now, do your laptop computers have the DVD players? And one scratch on the DVD, entire digital evidence goes. One magnetic field, and your digital evidence is gone, which is preserved on a DVD or a pen drive, thumb drive. So where to keep this? So the central government come up with an idea of e-Saksh portal. There will be a central repository wherein all the police evidence, whatever police has collected for search and seizure and crime scene recording, they will be kept on a platform, and we will provide you the access. Now question comes, what, who will maintain, who will archive that, who will have access control to that? What about the preservation of, who will be responsible for preservation of those electronic evidence? What should be the time limit for preservation? Our appeals get decided in 15 and 20 years. So we need to preserve that electronic evidence for 20 years at least. Then how to exhibit those electronic evidence in evidence? What will happen to admissibility of those electronic evidence? These are very pertinent questions. We may need to make rules on that. So we need to make rules for reception, storage, retrieval, access management, preservation of the electronic evidence. Rules are required, sir. Second, sir, where to keep? These are e-Saksh platform provides only for two things: the AV recording of search and seizure and AV recording of crime scene. What about the other digital evidence which are coming to court day in and day out? The CCTV footages. Every criminal case is, there is a CCTV footage filed either by the prosecution or by the defense. Call details. There are multiple, sir. WhatsApp chats, communication through other social media. Where to keep and all these digital evidences secured in our custody, in the custody of the court? Have you ever thought of planning a digital malkhana in the court? We don't have, sir. We have physical malkhana where the physical files are stacked, but we don't have digital malkhana. We don't have capacity to keep those digital evidence secure for years together. Tamper-proof boxes. We don't have. So we need to think on these directions also. Then Rajasthan High Court has done wonderfully well for this e-summoning. They have prepared the rule first, then lodged their Twarit. Madhya Pradesh has also done that. Why it was required, sir? Recognizing the service through electronic mode. The Bharatiya Nagrik Suraksha Samhita merely says that the summons can be served through electronic mode, but it does not provide for recognition of that service through electronic mode. So we need to create rules for that. There should be rule regime. Then video conferencing rules. First came in 2018. Then thereafter, there had been many changes in VC platforms. Again, sir, when a witness deposes through a video conferencing, how would you show him the copy of will and ask him, where did you sign this will? Exhibition of that will, how will you prove? Are you going to send the physical copy? Ask him to wait there at Calcutta. I am sending from Madhya Pradesh, and thereafter we will commence your evidence. No, sir. We need to provide a rule regime for these kind of challenges also. Then, sir, from where he is deposing? From the luxury of his home, sitting in front of the WhatsApp screen, and the person is holding gun on his head. We need to recognize the access point, remote access point. We are replicating the court atmosphere through a medium of distant connectivity. So we need to ensure that the atmosphere of court is created through this medium also. We need to have the rules for that, sir. Then Honorable Judge was discussing about pan-India rules, sir. At least uniformity in the nomenclature. So that is not feasible. My humble opinion is that that is not feasible because the high courts are independent in themselves. They make their own rules. No one can guide high court to create rules as per convenience of the statistical information. When this national judicial data grid started, sir, this challenge came to fore because every high court had a different kind of nomenclature. Then an exercise was undertaken to map whatever nomenclature you have in your jurisdiction with the nomenclature in other jurisdiction. Those were maps, and a common national this thing statistics was created and ported on national judicial data grid. The ideology behind that was, when we indulge into trade with China, we don't ask them to recognize rupee for trade, or we don't recognize their currency for trade with us. We don't ask them to learn Hindi or English first. They don't ask us to learn Mandarin first. We create a bridge between us, and we communicate. So that's way we can communicate with other high courts. We can create a bridge software that if high court is saying that it is a miscellaneous petition, we will understand that it is miscellaneous petition in their jurisdiction, but it is miscellaneous application in our jurisdiction. So this kind of things we can work out, but we need to have the rule. I'll restrict myself on this rule. I'll again, if you permit, I'll speak on that process alignment and re-engineering later.
Yeah,
Thank you.
please do.
Brother Sanjeev, you stated everybody here with this. Yes, is right in that way. You have to this make the rules for this purpose. What he has this electronic evidence, how to prove, how to do all these things. So I think so. This is the area where we have to ponder. And this e-committee, yes, certainly e-committee is not having any mandate to force the high courts to do that, but some way has to. We have to find some way.
No, we can advise. It is up to the high courts to actually accept or not accept, or accept with modifications they consider appropriate. On the panel is also Mr. Jay Thareja, is CPC Delhi. Maybe we can hear him also what he has to say on this.
Thank you, sir, for this
Personal
opportunity.
experience.
My remit here, I guess, is to be extremely brief. So, first of all, I would like to thank. Don't think I have the benefit of having Justice Mohammad Mushtaq in the room, but I'd like to thank him for giving me this opportunity of being on such a platform. It's a rare thing for a judge of my station to be here, and given that we are running short of time, so I just have very few points to make. Some things which are relevant from my vantage point. The first is that if a high court truly has to achieve process reengineering, there has to be some synergy between the rules committee and the IT committee. And one way I would suggest of achieving that is there should be identity of members. At least 2 or 3 members in both the committees should be the same. That results in very quick transmission of ideas and plans. The other suggestion or idea I have is that the registrar rules of the High Court should ideally be someone who's previously been CPC. I'm not pitching a case for my elevation to that position, but or somebody who has been a master trainer of the E committee, because that again makes this process of alignment very easy between those 2 committees. The next thing which I have to say, I agree with Justice Bishnoi. Process realignment, reengineering, the precondition is e-filing or digitization at your level. Apart from that, I genuinely believe that every high court needs a data center. That is the center point at which you are supposed to house everything. And if today Madhya Pradesh is succeeding as it is succeeding, it's because of that excellent data center that they have. So that is a precondition. That is where every data of the High Court, of the District Court should be brought in. And then we have to see how the processes can be aligned around that data. And the last input that I have to give is that a lot of process reengineering is coming from the legislature. As Sir has rightly pointed out, e-Saksha. But we are now even looking at MedLeaper and e-forensics, where the legislature and the executive now want us that the MLC should also be stored with them. And as a judge doing a trial, I should only get a hyperlink through which I go to that particular portal and access that MLC. So the question is, do we want traditionally the document has been housed with us? Once the MLC comes on my file and it is with my Ahmad or my court custodian, I maintain the sanctity. If it continues with them, then yes, you can probably involve blockchain technology. But what it only guarantees, as I've learned now, that if there is a change, I'll get to know there's a change. But the original document is most likely lost. So we, while doing our criminal trials and this criminal jurisprudence, really need to think that whether these e-sakshas, these videos made by as per section 105 of BNSS, the MLCs, the postmortem reports, and the forensic reports are to be housed with us, maybe as a copy, or are to be still housed with the state, which is a litigant before me and fully capable of, as I have learned reliably in my tenure as a CBI judge as well, fully capable of tampering with them. So this is my input on the subject.
Now, what happens if there is electronic evidence and you store a copy, as you said? Does it not become secondary evidence?
I concur, sir. And I would genuinely believe that a lot of process reengineering would, apart from requiring change in rules, will require change in statute.
Then what is having your own data centers? There's been a push towards cloud storage also.
Yes,
But
sir.
personally, I may think of data storage on site with us. But then there's been a great push for cloud storage
I
also.
know, sir. As a CPC, I have encountered documents of the government of India insisting that we should go towards cloud storage. But I absolutely concur with you. I have always been susceptible about keeping things with the executive on the other side. I want control with myself, and that's the view which my chairperson at the Delhi High Court also shares.
The cloud is being pushed by NIC, definitely, not by the government. Uh, we are also looking at the cloud model that has been, which the committee has been paying for the past several years. And I realized that the cloud service is not being offered. What we have been paying for is the hardware, the number of servers. A cloud service is never hardware, it is a service. So that is also something we are taking a relook at. Any questions from the audience?
Sir, I have a question. I'm Anup Chitkara from Punjab Haryana High Court. In e-Sakshya, when the evidence is uploaded, how do we supply the copy to the accused?
Actually,
Because even if the rules have to be framed, question is it is not downloaded.
no, it is not being downloaded. This is one aspect which we are working on. Almost about 40 meetings have been held between the team which is uh, designing the software and the committee. So this aspect has not been resolved.
What would be the consequences of the trials which have been held without supplying them the e-Sakshya documents? It will be a fatal defect.
Yes.
I'm Saurabh Banerjee from Delhi High Court. Now, there's another issue with respect to what Mr. Thareja was also saying. The supplying of the MLC uploaded in the cloud or whatever it is, the moment it is sent for the trial commences and the evidence, whatever the witness or whoever it is, the prosecution, they ask for the document. The moment it is open, the number of times it is opened, the logarithms change, and then it is no more a primary evidence.
Actually, this is one of the instructions that I have already issued, that the hash value should not change. And even if it is being displayed, while it is being displayed, you also display the hash value which should match with the hash value of the original.
So with respect, I'm just saying that. So in my little knowledge, I'm not even connected or anything. In my little knowledge, sir, when a document is created, the original hash value has to remain. And if the banking is on the e-document in the MLC or any form, then please appreciate, sir, the trial court needs to go through that day in, day out if the course of 13 witnesses or 14 witnesses are there. There is a probability of minimum 20 to 25 changes. So what I'm just suggesting, I don't know what the hashtag remains, the original hashtag remains. The number of additions, alterations, whatever it is only supposed to be recorded in the order sheets. Then there is no change in the document per se. The primary evidence still is the primary evidence of the original hashtag. I don't know, sir. This is my suggestion. This is what.
So the hash, when it's generated on any document electronic, the original hash is recorded. The original hash is recorded. The change happens if it is saved or transferred to another medium. When that change happens, there's a different hash value. What could be generated is a chain where the changed hash value is also recorded on the chain, like blockchain, what we spoke of, that there's a hash value 1. It became 1.1 because of this particular thing, but it's always traceable to 1. So the Angama on hash value, which is the Defense Council makes out, he wants to make it out because he wants to throw a doubt into the mind of the judge or mind of the appellate court. But the hash value, if we go back, the hash value of the original always remains the same. It's only the change which needs to be recorded, and that process, if it is taken care of, everything falls in place.
So just one more thing. Accessing the document will not change the hash value.
Accessing per
And
se will not.
just having a look at it and then closing it again, it's not going to change the hash
Yes.
value. So usually in criminal trials or civil ones also, the documents which are they are seen by the court. And the question arises when an exhibit is marked on it. Whether the hash value would change
Changes.
when you mark it.
Again,
So if we make annotation on a document on the electronic reader, annotation we say change. If it it is a layer on it to make classify it as so, but when it gets saved, it's a new document.
Yeah.
It's a new hash value. So if we have the original document stored without any change, and the documents which are accessed with annotations or otherwise, that is immaterial because we can always go back to the original filing
Correct.
to verify that hash value. Unfortunately, during the time of argument before this is where some training is required for the district judges and the magistrates that don't get enamored by this change in hash value. Go back and refer to the first hash value. This hash value has changed. It is bound to happen. And there's no harm in it happening. But just refer to the first hash value to find out what is the actual hash value and compare it. Don't go by the argument or the defense because that is what they are paid to do and that's what they will do.
What?
Yes, there's a train. There's a trail which can, there's an audit trail which can be established. Yes.
No. Sir, what with Justice Sreedharan? Sorry.
Yes, I'll answer to
So what
I'll answer to your query. See, electronic evidence is preserved by hash value in eSaksh portal.
Yes.
Yes. Thereafter they came to me. We had a discussion. We said all the subsequent changes should be kept in a package file,
So that's
which is attached to the original document. So, like the date of its creation, the time of its creation, all these facts are kept in a package file attached to the original document.
so that's
Even when you mark the exhibit on the document, the document is referred to and admitted in evidence, that exhibit marking or any material object marking
Reverts back
will
to the-
again go to that package file without disturbing the authenticity of the original document. So that has
So the
already been taken
original
care. It is
I,
done.
I agree. So the original document remains as
Same,
it is.
same.
What is being used is a secondary part. Whatever, how many times it is opened, how many times the marking is done, it all reverts back to the original document as such.
It will not revert back. It will be saved in a
Hashtag.
package file attached to the original document.
The hashtag will remain same.
Yes,
because
yes.
it's there. That's
Hashtag of
that's
original
exactly.
file shall remain same. Another query you raised that about that Medlipar report, that medical reporting. Madhya Pradesh is facing another peculiar position on that. All the revenue records have been digitized in Madhya Pradesh. And now they have stopped giving the certified copies, saying that whatever we have already put it on the website. You access, you put in your survey number and access the document. Is
Sir-
that a certified copy of the electronic record?
Sir, I was sitting in a division.
Unfortunately, it's
Sorry.
no.
I was
So
sitting in a
that is a big challenge. We are framing the rules to recognize those documents which are kept on the server of concerned revenue department. Again, rule regime is required.
So there is
Whenever our rules are passed, we will be happily sharing with you.
right.
Any other suggestion or something? Koi query?
Problem just a problem we may face with regard to uniform marking of application suits or whatever. In some high courts, the writ petitions are filed before a division bench. In some high courts like Calcutta, writ petitions are filed before single benches. Then the question comes when whether an LPA would lie or not, whether it comes under 227 or 226. That is one issue. There is another issue. For example, criminal revision matters are filed before single benches in Calcutta High Court. Whereas in many high courts, 226, 227 and CRP and 482 are filed in one petition. Bombay. So the nomenclature to bring a uniform nomenclature will be a real challenge.
Earlier, the exercise was mapping it.
Sir.
And if I remember correctly, the biggest opposition was from we received was that the larger high courts, citing that they have a history of 100 years or 150 years, they are not ready to change their nomenclatures. So that was it. But still, it could be.
It can be done,
Yes,
but
yes,
then there has
for
to be
last
uniform.
3 decades, it could not be done. The work has been taken up by the Chief Justice Conference, probably in the late 90s also. And 2017, what has been done, it has yet not been implemented. So the issue really is a debatable issue.
So with the permission, just last thing on process reengineering, I
please.
reserved this for the finale, the cherry on the cake, sir. Process reengineering, sir, it requires mindset reengineering first, not the process reengineering. Process reengineering will follow. I'll just make an incident, sir. Police authorities, when we started this e-summon, police authorities came up with a wonderful objection that, sir, we need to purchase first the tablet computers to serve the summons, and again we need to train them. So it will take time. Don't implement it. So I asked him whether your constable these days have the smartphones or not. Well, sir, they have, but they don't use it. So I asked them, these days, if a person is having a smartphone and don't know how to use it, he must be a sadhu, still using Nokia 2010, or a shaitan who is watching YouTube, messaging on WhatsApp, but he don't want to do this official work on his. So instead of giving them tablets, give them an app which is inbuilt in your in their mobile phones. Pay them for internet charges 300 per month. They will happily accept it, and they have done it.
Sir, I'll just say
Thank you,
one
sir.
thing.
It's mindset engineering. That's it.
Just with permission of Justice Bishnoi, one thing. In my court, the cases come regarding e-Sakshya battery debt.
These are the so these are the some challenges which we have discussed thoroughly here, and some certain points. Just as brother Maithani, brother Sreedharan, and particularly brother Sanjeev, they have raised very pertinent points, and we have to find answers to these queries. If we want to achieve this e-filing and all these paperless courts, then these are the challenges which you have to met. Rules have to be amended. Very pertinent point that electronic data where to save and up to what time, how many years you have to save. You have to find an answer for that also. And for that purpose, you have to take together the government also for that very purpose, and to make understand the high courts also that yes, these are the necessary changes, though you are independent on your own, but please do these things for the purpose of achieving a goal for that, sir.
Just to add one item, sir. Today, the cost of implementation of AI, which we are speaking of, to get one GPU is going to be difficult for each high court. We need to have a shared infrastructure for the purpose of GPUs. GPU we can order today, even if you have the money, it won't come because there's a full queue which is available. It's only at the Supreme Court level that probably the GPUs could be secured, because Supreme Court will get, the E committee can get the GPUs. If we have 5, 10 GPUs, that could be shared among all the high courts, and that resources would be
We
available.
are working on.
Yes, the 5 GPUs are coming now. So that could be shared.
One more thing, sir, just wanted to add is with regard to security, I mean, part of process re-engineering, especially what happened in the Delhi High Court. They had a robust system apparently, but there was a digital backdoor through which the hacker got in. He priced himself through and did something mischievous. But he stopped only as far as the screen is concerned. He could have gone further and had access to the servers and created mayhem there. Is it time that we start thinking in terms of a cyber security officer, which is a slightly more better term for a ethical hacker, who would consistently test the validity of our systems to find out how robust they are before the person with malicious intent actually sees it?
Absolutely.
CDOT has certain tools for monitoring. One tool will monitor externally. There is another tool which does an internal audit as well. So that is something that can be
In
used.
fact, a couple of
But,
years, sorry, please go ahead. A couple of years back in Madhya Pradesh High Court, the front page of the High Court got defaced. A casino's poster was put up there. Anyway, but as a metaphor, that must have had some kind of a meaning that whether you go to a casino or to the court, it's a matter of chance.
So you raised
Like-
the
like-
issue about Delhi High Court. It's not something which is peculiar to Delhi High Court. We also suffered the same in Karnataka. There were 2 other courts also which suffered the same, where Russian hackers, then it was only jumping around, nobody knew from where it was coming. We have started using a software which Kerala started, vConsole, which is user authenticated. So that is something that we'll have to do multi-level video conferencing rather than point to point, which are these Zoom, WebEx. They are not made for courts. They are made for a commercial meeting. So we need to come up with our software for this. vConsole is one which I would recommend for all of you to have a look at.
No, we can also, perhaps the time has come to have a kind of expert team like Government of India has certain kind of certain the organization. So my experience is twice the Supreme Court website was hacked. So we had to approach those authorities, those people. They are very senior experts or different from different fields. But it took a lot of time even to take them on board. So this is in Supreme Court. What happens in Uttarakhand High Court? Something like this happens. So we can have a kind of certain kind of organization within judiciary, which could be maybe under e-committee or something. Some
Actually, even
recovery kind of team.
even certain is being advised and is banking upon these tools which I said have been developed by CDOT. They are,
Then, in fact, one interesting fact has been given to me by Justice Kalgaonkar. The question is who manages the cloud services of NIC? This is in support of what Jay said. Meghraj is the cloud service. So in support of what Jay said that we should have our own first servers. Can anybody guess who is managing the NIC's Meghraj service?
Geo.
Sir, can I say something from Madhya Pradesh High Court? Uh, Basically, we have to store the data where? Our data center or the cloud. We have to manage things internally or externally. So we have to think about 2 things, sir. The E-Committee Supreme Court of India have given the SOP 1.0, where 3 options are given. Either you create your private cloud in your data center, either you
It
take
is
the
precisely what we are looking into. We are doing a rethink.
yes, sir. Or you take
You will
the
get an answer very soon.
or you take
So
the
one more aspect, sir. I'm Aman Chaudhary from Punjab Haryana High Court. NIC is looking at e-Sakshar. So I don't know if we need some other player to look at it. The
Actually,
integration is not
It
happening.
is a team of NIC Madras which is doing the software in conjunction with the Home Ministry.
Yes, because I had taken up this point and they were very prompt on saying that we've been able to manage, but I don't think it's working. Defense councils are already taking
They are still working
advantage.
on CCTNS
And
2,
okay.
which was supposed to be launched on the end of February. That February end has not yet arrived. Let's see when it arrives.
And one more aspect regarding the witnesses appearing from abroad. They are also unable to because the time difference is so much.
that they're unable to go to the consulate. So a lot of petitions are now being filed. So some rules have to be also brought in place for that aspect, that how they would be able to record their evidence if somebody is ailing and old and cannot come to the country, still wants, he's a complainant or an injured witness, and his examination is imperative. So how would that be? Because there are
That's what we are
judgments coming.
discussing that
I
it's
passed
not.
one judgment on that, but of course rules are better.
That's right. We have, this is what we are discussing, that what type of challenges we are going to face and how to find a way. So it's a very brainstorming session, and I hope that we uh, we are going from here with some suggestion, but lot of more questions also. So we have to find the way, and and the Sandeep is reason for that. The Sanjeev is reason for that. It's anyway. So I've been told that we are getting late because the dinner time is also there. So we'll take our leave. Thank you very much.
Thank you.
Thank you, Lordships in the dais and distinguished guests for this engaging session. Honorable Lordships and our distinguished dignitaries, with this, we conclude today's session. We extend our sincerest gratitude for your presence and invaluable contributions to this conclave. The technical sessions will continue tomorrow as per schedule, and we look forward to your gracious presence. Thank you and wish you a pleasant evening.
Yes.
Yes, Lordship. The eminent dignitaries have also been called for dinner by the state government. Also, ladies and gentlemen,